talk to you this morning about, thank you. Welcome everybody to House General and Housing, and today is Friday, April 25th, thank goodness. And our first witness is Steve Howard. We're continuing to hear S-125, which is an omnibus bill on worker rights and collective bargaining rights, et cetera. And we probably will hear, and we'll definitely hear more this afternoon after lunch at 1 o'clock. And Steve, feel free to, both Steve and Tom, to speak broadly to the issue. I know I talked to you briefly this morning and said there was a concern over supervisorial personnel, but that it goes the bill goes beyond that, so don't truncate your testimony. Whatever you're going to testify to, please go ahead and take it away.
Okay, thank you, Mr. Chairman. For the record, I'm Steve Howard. I'm the Executive Director of the Vermont State Employees Association. And I am joined here by Tom Abdelnour, our legislative coordinator, who I may phoned a friend for.
I'll tell you what, Tom, would you introduce yourself for the record?
Certainly, for the record, my name is Tom Abdelnour. I'm the legislative coordinator for the Vermont State Employees Association.
All right, it's because that way, if both of you want to testify jointly, you can. In fact, Tom, do you want to grab a chair and sit up here?
Whatever.
You'll have a chair over there and sit down, and we can, that way, if you both want to testify together,
Okay,
you can do that. I leave it as between the two of you who is allowed.
It's all right.
It's Friday. All right.
Thank you, Mr. Chairman. So VSEA, I'll just repeat that VSEA strongly supports the S-125 as it was passed out of the Senate. Today, we are joined with a couple of friends who have come to help us. Chris Doobie from the, I call them the powerful professional firefighters of Vermont, who are here to support the Section 5A on decertification, and also the executive director of the Vermont AFL-CIO, who is here, JP Isabel, who is here to support the bill as passed by the Senate. And I believe they intend to submit some written testimony or at least a letter of support at some.
Gentlemen, will you be submitting your testimony in written form? Or were you hoping to speak?
I can do both. If I speak, it's only gonna be really brief on that.
Well, I'll tell you what, I think, let's go ahead, and if we'll have time, that'll be fine. Go ahead.
So I'm going to start with Section 5A, which is the language about decertification. And you heard me talk about this in my previous testimony. Really, so I won't I'll try not to repeat too much of what I've already said. I think VSEA's view is that this provision increases the chances for what is called labor peace, and allows for the labor movement to be unified and focused on the needs of workers and enhancing the working conditions, the benefits, and the compensation for workers, and not constantly in a battle with a union that can trigger an election with just 30% of the unit, including non-members who chose not to join the union in the first place. We believe that the 70% have a right, a constitutional right, the right of free association in the U.S. Constitution, which is supported by the proposition that you passed out of this committee just this week, Proposition 3. So we'd ask that you support that concept. And it really doesn't eliminate anyone's right. It elevates it really eliminates the ability to trigger an election without a substantial showing of support. And if there is a substantial showing of support, yes, there should be an election. And there's a big difference, as you know, from when you get your signatures to put your name on the ballot, between the folks who sign a card or sign a petition and those folks, the decisions folks make several months later when they vote in the privacy of the voting booth. We believe the standard as passed by the Senate at 50+1 is the right standard, and there's no need to change existing statute for the election number, but we support the change in the number of signatures to trigger an election, 250 plus one. And we really, I think we just want to say this committee has a history of, a proud history of standing on the side of workers, standing on the side of labor, and really supporting labor, which we are really grateful for. And we hope that that will continue with your support of the Senate bill as passed by the Senate.
Can I ask a question about that?
Sure.
That piece? Just to clip, I'm pretty sure I get this, but I just want to make sure I do. So when people collect signatures, are they just sort of going around to the workers with a sheet of paper asking for their signatures? Is it like we do when we collect signatures?
It's similar, but it's a little different. You collect what's called cards. So you have to collect, basically it's the same thing. It's just a little bit more information on the card.
I mean, for decertification.
Yes. So it's basically you circulate cards that say that you sign and say you are signing with the intention of triggering an election.
Is it just as a practical matter, since this is new to me, is typically just a packet of cards delivered and put in the mail of every employee, or do union reps or other people go on the floor of the factory and hand people cards and ask for signatures? Or
Yes. So we're having, so that's a very important point. Under the state policy, at least for our union, you're not allowed to organize on state property. You're not allowed to solicit on state property, and you're not allowed to do that during working hours. Generally, I think folks collect cards on their own time, off campus, at meetings they may organize,
or
however.
at the gate of a plant. They
Yeah.
can stand at the gate.
Yeah,
Okay.
it's a little bit. I think that's basically how it's done.
And conversely, an election, let's say you get 50 plus one cards or whatever is. I take it the election, once that provokes an election. And what's that like?
So what happens is the cards are submitted to the Vermont Labor Relations Board, and they go through just like a town clerk would. They go through the cards and they look at the signatures and they verify that those folks are in fact in the bargaining unit, and they certify whether or not they have reached a sufficient number of signatures to trigger the election. After that, there's a process. There's a hearing that usually occurs at the labor board where both parties, and this sort of delves into the judiciary a little bit, both parties come to the labor board and we say, here is the list of who we think is in the bargaining unit and who we think should be included and should have the right to vote. And management usually comes in and says, we dispute that these positions should be in the bargaining unit, and we think, the rest of the folks should be in. And what generally happens is there's usually a mediated settlement.
But with decertification, I assume that's much easier. There already is a bargaining unit.
Yes.
There already is. Okay.
Yeah. Decertification, there is already a list that is available.
And then what happens?
So what happens after the cards are certified, then there's still a hearing, and there is a discussion of when the election will occur. The elections are administered by the Vermont Labor Relations.
So what is the forum where the union can appear and say, you should not vote to decertify, and the proponents of decertification get to say their piece? How does that campaigning work?
It's not dissimilar from a political campaign that you would experience in your realm of expertise. It is, first of all, I should say that the voting is done by mail, which at some point we may come back to you and say, let's update that, because the Postal Service is not always as predictable as it once was. Like we get our mail in Montpelier once a month on Sunday afternoon, usually from mail carriers from Rutland, actually. There are no mail carriers in Montpelier. So that's a different issue, but what happens is that the ballot, the data set, the ballots are mailed out. You're given a certain number of weeks to return the ballot. It's a little complicated because you have to fill out the ballot, you have to sign the outside envelope, you have to put it in the envelope and seal it, kind of like an absentee ballot, just like an absentee ballot. And the campaigning, it depends on your strategy, but it's you reached out to them very much in the same way you would reach out to voters in your district.
Right.
You sometimes visit them at their house, knock on their door. You would reach in the mail. You'd reach over social media.
So there's no, I just wanted to know, there's no requirement that the employer provide a place where there is, everybody can come and there's discussion, debate. It's not like,
No.
it's not organized like that.
No.
It's like a political campaign.
Yeah, and in fact, the employer is required to stay out. And if the employer shows, by virtue of either party, a bias towards one of the unions competing, that would be subject of an unfair labor practice.
Got it.
That would be filed at the labor board by whichever union feels aggrieved.
Thank you. I'm sorry to slow you down, but I just.
No, that's fine. That's
Okay,
fine.
go ahead.
So I think that's really what I had to say about that section, and then I'll ask Tom if this is okay with you. Tom may have some further testimony on the section that would allow our members would allow supervisors in the judiciary the right to vote on whether they want to have a union.
Please proceed, Tom.
Thank you, Mr. Chairman. And I will just add very quickly to the excellent recap that Steve provided of the decertification section. There was a comment the other day, and there may be comments this afternoon about, well, if we raise this, won't this perhaps be in some way jeopardizing the right of workers to trigger decertification? As Steve alluded to in his testimony, I thought very thoughtfully, it's important to remember too that there are other fundamental rights that are important to safeguard when it comes to employees in their workplace. And one of those is the right that we all have under the First Amendment of the Constitution of the United States to free association. And so I think it's important that a small minority of folks not be allowed to throw that important fundamental constitutional right into jeopardy in a given situation because of a small minority trumping the interests of a larger majority. But moving to the judiciary supervisor.
But I know you know this at the top of your head, the 3 states that are already at that threshold.
So-
The 3 states with those thresholds, yes,
Hawaii,
Massachusetts and Ohio.
In Ohio, okay.
well, and also, yeah, they're the ones at 50%, although there's Oklahoma is at 40%.
That's correct.
Right. Yeah, okay.
That's correct. That's correct, Mr. Chairman. With regard to the judiciary component of the bill, I guess I would just make a few short points, some of which were addressed in the sort of previous free-form discussion that took place the other afternoon, but I think they're important to reiterate. These supervisors in this language in the bill, these folks are seeking simply the opportunity to vote on whether or not they would like to be unionized. And there are a variety of questions that come up in the process of unionization. So a couple of which were raised by the court administrator in her testimony the other day and by Mr. McNeil. But I would say that it's really important to understand that the Vermont Labor Relations Board is routinely and regularly addressing these issues whenever a new unit is organized. They address them as a matter of course, and this is not new and challenging for them. This is their sort of bread and butter as an entity. So there was a discussion the other day about the potential size of the unit. The judiciary had one position of what they anticipated it would be. We anticipate that it may be a different number than the judiciary anticipates. And on that point, I guess I would make 2 points. First, again, every time there's a new unit that's organized, the board has the ability, upon hearing the arguments of 2 sides of who should be in and who should be out of the unit, to weigh in on that matter. And so it really is almost immaterial what each of the 2 parties who you've heard from in this case thinks the number will be. Because ultimately that's a determination that will be made by the board and that should be made by the board. But I will also point out, just as an aside, if the judiciary were correct in their assertion that there'll only be 4 folks who would be a part of this bargaining unit, our position would be that those workers in the Vermont judiciary should be able to avail themselves of the same right that a wide swath of workers across the state enjoy, which is to be able to decide to form a union. And the fact that there only happen to be 4 folks, if that were the case, should not prevent them from being able to form a unit.
Or try.
Or try to. That's exactly correct. That's exactly correct, Mr. Chairman. I did also just,
Question.
oh, yes.
Why do you think there's a discrepancy between what you believe your numbers are and what the judiciary thinks their numbers might be?
I guess I would say that I mean, as we heard from Ms. Zadatny the other day in her testimony, the definitions in the 2 sections in CELRA and JELRA of who is a supervisory employee, those are almost identical between the two pieces of legislation. And I would say, as Steve alluded to before when he was talking about election, it is routine and almost more commonplace than not that a union who may be involved in supporting the organization of a unit and the employer in question may have differing opinions on who is and who is not. I would say that is more the rule than the exception to the rule. And that is why the board has a long history of reviewing those situations, hearing arguments from each side and reaching a decision, which typically happens without controversy in a very routine way.
Is it, like, for example, I just want to concretize this.
Mhm.
I'm assuming that in a situation where a union is proposing a new unit, or the members of the unit are proposing a new unit, if that's the way, however it happens.
Yes.
Management might argue that people who are listed as supervisorial or not, they're managerial.
That is
Or they would argue that they're confidential.
that's exactly.
The argument why. And the union would argue, no, they're actually supervisorial, or maybe, and maybe not, they're not confidential, and here's why.
That's exactly correct, Mr. Chairman. Those are the sorts of conversations that are had before the board. They hear each side, they weigh the definitions set out in statute, they weigh the arguments that most sides make, and they make a determination.
Okay, thank you. Joe,
I have a question on that same line. Assuming that I'm guessing you've looked into it to come up with whatever number you kind of think would fall in that category. Like I said, assuming that the judiciary, when they came in, looked and said, well, who fits this category? And they're currently not members, so we think this is the group you're talking about. Would that discrepancy, are those currently unionized members or not unionized members?
That's a good question. So they're not unionized members because as it stands under the Judiciary Employees Labor Relations Act, or JELRA, these folks by definition do not have the right to organize. And so to your question, no, I don't think any of the employees, either that we or the judiciary think would be part of an eventual supervisory unit, I don't think any of those folks are currently eligible to join.
yes,
Sorry, I have one last question.
Of course.
If it's better for later, just let me know. The judiciary was here, I think you were in here when both Terry and Judge or Attorney McNeil were in here.
Yes.
They have concerns. I'm still trying to wrap my head around their concerns. It sounds like their biggest concern is that there's only 4 members.
I'd say that's right. And that was, I don't want to speak for the judiciary, of course, but that did seem to be their primary concern. Again, as I said before, even if that were the case, I don't think that the small size of the potential unit should preclude these folks from being to exercise their right to organize a union if they should so choose. But I am happy to address briefly one of the other concerns that they articulated in their testimony.
Yeah, that would be wonderful.
And that was the concept that somehow in and of their very nature, that a supervisor is not really an appropriate person to be able to unionize. And that this would be flying in the face of labor law to allow supervisors to unionize. I have to say, I was very surprised to hear that testimony, because the state of Vermont has been operating under a situation where supervisory employees in state government can unionize for decades. And this morning, knowing that I would be coming in and speaking with this committee, I reached out to our colleague, Gary Hoadley. Gary is, what, Steve, 30 in his 30th year or something? 31st year with VSEA. And has a long history in the labor movement. And so I reached out to Gary to see just how long has it been that supervisory union employees across the state have been organized in their own bargaining unit, in the same union as their peers who are not supervisors. How long has that been going on with no controversy and no issue?
This is the executive branch.
Exactly right, Mr. Chairman. There's an executive branch supervisory unit that has been around for decades and that has, Steve, I would say, what, probably a couple of hundred members?
Yeah, at least that.
At least that. My colleague informed me that it was 1977 where supervisory employees in the judiciary gained the right to form a bargaining unit. And so for almost 50 years, these folks have been collectively bargaining with their colleagues and in the same union as, but different units than their non-supervisory peers. There has not been a, yes.
That's in Celera, right?
Exactly correct. That's right. That's in Celera. There's been no issue. There's been no controversy. There's been no problem. And so I think you, Mr. Chairman, articulated the other day that you were not entirely persuaded by the argument that supervisory employees are somehow inherently unfit to serve as union members. We completely agree. I think that analysis is exactly correct. And I guess when the judiciary said what makes their supervisors different than other supervisors, they said, well, our supervisors would have a very different role. Again, I would point out that the definition in both GELRA right now and in CELRA, the State Employees Relations Act, as Ms. Datney said, is almost identical. So again, the board, who have been able to very successfully determine what the executive branch supervisory unit would be, would I think apply the same kinds of tests to the judiciary in determining what that unit would look like. And I guess the final piece of their argument that I'll respond to briefly, unless folks have any other specific questions about their testimony, was this idea that because supervisors are supposed to sort of carry out the policies and mission of their employer, that house somehow makes them unfit to be union members, because you'd have to sort of, and I don't mean to put words into the judiciary's mouth, they'll be able to speak for themselves this afternoon. But from my read, the implication was somehow that they wouldn't be able to be fully trusted to implement the policies and mission of the organization because they would have some sort of split allegiance between the Department of the Union. From my perspective, and I think Steve would agree with this, if responsibility in one's job to carry out the policies and mission of somebody's employer would make you ineligible to join a union, then I don't think that any employee in this state would have the right to organize. Because everybody works for an organization that has certain policies and certain missions. They're responsible for carrying those out. And nonetheless, the state says these folks should have the right to be able to come together to collectively bargain on issues like pay and benefits. So simply being an employee of an organization with management that has a particular policy does not, in my opinion, or in VSEA's opinion, disqualify somebody from being able to use their right as an employee to come together. So I think, Representative Barley, that addresses the bulk of the points raised by the judiciary in their testimony.
Thank you.
Any further questions by the committee of either of these gentlemen? Thank you, both of you.
Thank you so much.
Would you like to say a few words?
I'm happy to, yes. I'll be really quick and succinct.
That's good.
We're just before lunch and
Yeah, I know.
before and just after lunch. So for the record, Christopher Doobie, President of Professional Firefighters of Vermont. Thank you for the off the hip chance to say a couple words. So this is in regards to the proposed decert 30%. Quite honestly, it scares me that such a low number could do that. Essentially, I could have one shift in a department decide they're mad at me. And in my experience, is usually when that happens, they're not mad at the union, they're mad at the person. It comes down to personalities. So with me as president, they could be mad at me, choose they don't want to be affiliated, and literally that one shift dictates what the rest of the department wants to do. So again, if anything, so I know with the IFF, our constitution and bylaws states that to decert or like to withdraw, whether it's from the international or the state association, that it's either 2/3 or might even be closer to 80%. So it makes it tougher. So that way you don't have those issues we deal with personalities, where somebody's mad because I didn't do something they wanted to do, and they pull in the rest of their shift and their shift gets together, even though the other two shifts are like, or three shifts, four shift rotation, they may be 100% on board, but that one shift is irate at me that they decide they're the ones that are going to dictate that and pull out of the organization. So I would encourage the committee to, if that wording is in there, I've skimmed it this morning, but to make it more on the lines of at least 2/3 to decert. That way it takes, in my experience, over 33 plus years, the personalities out of it. So
What's before us is 50% plus one,
is it? Okay, yep.
as
And
opposed to
I
30.
mean, like I said, I know, but with our bylaws, with the international, we make it a little tougher. So I'll be clear. When I go in and I do an election for local wants to come in, be it whatever, I'm working on 2 or 3 right now. Most of the time, it's 100% of the membership votes to join the union. I know that constitution bylaws, when it states that to withdraw from the organization, you got to have at least 2/3 of that membership to make it a little tougher. I'm certainly happy with supporting whatever position my state VSEA members choose. I can understand that being a little more in line. If it takes you majority to certify, it should be a majority to decert. So that would be my 2 cents on it.
Yes, go ahead.
I'm confused, so please help me understand.
Yes.
Bylaws can be different. So if your union bylaws say 80%.
Mhm.
How many, maybe this.
I'm just, you know what, I think Sophie
Okay,
can help us out there. What you're pointing out is how much of this really is a creature of state law versus whatever their internal policies are.
exactly.
And I think Sophie can answer
Okay.
And
that.
I don't mean to confuse. So yeah, so we have a multi-layered. So you have locals, we have the state association, we all work under the IFF.
Yeah,
So the local would come in and do their elections.
Yep.
We do the elections with the Vermont Labor Relations Board. They do the card. It's historically been, since my knowledge in the last 30 years, 100%. So when the municipality comes to us and they want to join the IFF, 100%. The IFF has constitution and bylaws, because we have a state association
Mhm.
that you are part of the state association once you join the IFF. Some locals, for one reason or another, get pissed off at the state association, and it happens across the country. Pittsburgh, for example, Pittsburgh and state of Pennsylvania withdrew from the Pennsylvania Firefighters Association. Again, based on personality conflicts, but my point is a small group. So it's kind of like this, but kind of not, that to pull out of that, it takes a larger number than to get in. So going to this, I could have a local, in theory, get mad at the IFF or the PFFE, and in literally one shift, I'll use like a 30-member department, 9 members could say, I don't want to be part of this union anymore, and pull out, which,
You could just
but
trigger the
my
election
understanding is that you can only do that during the open period.
You
So I
see,
can't
think
just
this is
want-
apples and oranges. He's
yeah,
talking about some local firefighters union that wants to withdraw from the National Firefighters Union.
Yeah.
Which is a completely different issue than state law, which controls when decertification, which is a different thing. In other words, I think, but I'll tell you what, I think we should ask Sophie to clarify this for us.
Great.
yeah.
Thank you.
So that's my 2 cents. I like to see it at least be equal.
Yeah, right.
In my mind, would be a little better balance. So,
Right. Thank you.
thank you.
Sophie?
It's gonna come some.
Excuse us. Yeah. Yes,
Oh,
sorry.
You might just initially clarify if you can. I'm assuming, but don't know, that in terms of decertification of a union or a bargaining unit, that state law controls whatever it is. Currently, it's 30% and the proposal is 50% plus one. that the state law would control and the internal bylaws of the union are not relevant.
I think that's my understanding. I think that it's, as you said, apples and oranges. And again, Sophie Sadatni for the Office of Legislative Counsel. So I think, that we're just drawing the analogy between, having a higher threshold, for certain things. But again, here we're talking, what the provision in front of the committee is talking about is decertifying an existing representative organization. What that, again, and I don't know anything about the firefighters, but I'm assuming, again, most of our units here belong to other unions. I mean, there's, again, you guys probably can explain better, but so to me, it would, my understanding from the firefighters thing would just be like, we're organized, we're happy to be organized the way we are right now, but we don't like the state organization, or we don't like the national organization, and we want to switch to a different one or whatever. That would be something that's set by the bylaws. What we're talking about here is the union that's representing the workers for collective bargaining purposes over wages and hours and working conditions. So that's a different issue. And again, here we're talking about what the process to decertify a union or to switch unions, and what are the thresholds required. And all this bill is doing is saying that the current threshold of 30% in order to trigger an election should be raised to 50% plus one. So that's really all that we're doing. And I know you're looking at lunch. I thought it might be helpful, because I did watch some of the testimony from yesterday afternoon, just to go through the current statute and the State Employee Labor Relations Act, because I think it might answer a number of the questions. But I don't want to maybe do that well, I could maybe do it this afternoon, because I don't think I can do it in 5 minutes.
How about it?
I think that's fine.
Why don't we do it this afternoon?
Okay,
That
I just
way-
wanted to
that
go
way
through
you
step
won't
by
be
step.
And people won't be listening to you with a rumbling stomach. Okay.
Might put them all to
so we're gonna
sleep, but that's a separate question.
Convene at 1:00, and at the risk of having my hand slapped because I didn't renew my calendar again. So this afternoon, we're gonna hear actually, at this point, we have 3 witnesses and Sophie. Great.
And before I finish, I see that Magali printed out. I just wanted to clarify that the 3 states that the VSEA has referred to, Ohio, Massachusetts, and Massachusetts. Hawaii, thank you. It took me a while to find the Massachusetts and Ohio threshold, so I just updated the chart. And then it has the thresholds for public employees in other states. And some of them only allow, a small number of their public employees to organize. Others have more general rules like we do. So I just wanted to flag that, because that was something that I was not clear on before. Just want to make sure we all have the correct information.
Do you have any knowledge as to like Ohio, when they went to 50, or have they been 50 all along?
I don't know the answer to that. And really, the only way I found it was through the actual petition itself, that, when you're completing the petition that gets submitted, on there, it talks about the 50%.
Great. All right. So this afternoon, we're going to hear from Terry, Joe McNeil, Chris Hoare, who's president of the VPA, the Vermont Police Association, and so.
Did you want me to go first on the decertification piece?
Yeah, why don't we?
That's separate from the.
Okay.
Okay.
Not that I.
And I'll try and do it
I know you like to stay here, and hang out with us on Friday.
I'm happy to stay for the whole testimony. I'm just thinking it might be helpful that then you would all have that understanding when you then hear the rest of the testimony.
Right, okay. Thank you.
Okay.
Members of the committee. At this point, I have communicated to the Commerce Committee that we desire to have a hearing with them present, or some of them, on the results of their work on the CHIPS. Remember, the tax increment financing part of what would become part of our bill. And I will keep you updated on how that's going.